Hello and welcome back to another episode of Courts This Week, your go-to source for the latest legal updates presented by livelaw. I'm your host Ostika Das and I'm here to take you through the most significant updates from this week. From the corridors of the Supreme Court to local judicial proceedings, I'll be providing you with clear and concise summaries that keep you informed and ahead of the curve. Remember, for a more in-depth understanding, do visit our website at www.livelaw.in. In today's episode, we cover the Supreme Court's stay on directives to eateries along Kanwar route, the top court's decision on NEET, Umar Khalid's bail plea and much more. So let's dive into the headlines. This week, the Supreme Court halted directives issued by the Uttar Pradesh and Uttarakhand governments requiring eateries along the Kanwar Yatra route to display the names of their owners. A bench comprising Justices Rishikesh Roy and S.V.N. Bhati issued an interim order while responding to petitions challenging these directives. The court clarified that eateries must still display the type of food being served. Petitioners argued that the directives promoted religious discrimination and questioned the authority of the state to issue such orders. Originating from the Muzaffarnagar police, the directive mandated all eateries along the pilgrimage route to display owners' names, a requirement that was extended statewide and enforced across Uttar Pradesh and Uttarakhand. Petitioners, including the Association for Protection of Civil Rights, TMC MP Mahua Moitro, and commentators Apurvanand Jha and Akar Patel, contended that this order threatened religious harmony and violated fundamental rights under the Indian Constitution. Senior Advocate Mukul Rohatgi, representing Uttar Pradesh, argued that the Food and Safety Standards Act 2006 requires all food sellers to display owners' names. The court noted that if such a law exists, it should be enforced universally. The Deputy Advocate General of Uttarakhand, Jatinder Kumar Sethi, supported the directive, warning of unregistered vendors posing potential threats. The bench stated that voluntary display of names is still permissible but maintained the stay against mandatory enforcement. Later in the week, when the matter was taken up again, Senior Advocate Dr. Abhishek Manu Singhvi, representing Moitro, requested additional time to respond to a late-filed counter-affidavit by Uttar Pradesh. Acceding to this request, the Supreme Court adjourned the hearing until 5th August, with the stay extending until then. In a significant decision this week, the Supreme Court declined to cancel the NEET-UG 2024 examination despite allegations of paper leaks and malpractice. The court found no evidence of a systemic breach that would compromise the integrity of the entire exam. The bench, comprising Chief Justice of India D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra, emphasized that ordering a re-examination would have severe consequences for over 23 lakh students and disrupt the academic schedule. Although acknowledging instances of paper leaks in Hazaribagh and Patna, the court noted the absence of substantial evidence to suggest a widespread breach. This decision came in response to a series of petitions seeking the cancellation of the National Eligibility Cum Entrance Test, or NEET, held on 5th May 2024 for undergraduate medical admissions. The petitioners argued that malpractices had tainted the examination process, warranting its annulment. However, the court underscored the lack of material evidence indicating a systemic issue. The bench highlighted the significant impact a re-examination would have on students and the academic calendar. The results of the NEET-UG 2024 exam were declared on 4th June and has sparked widespread controversy owing to allegations of paper leaks and malpractice. This week, the Supreme Court delivered a split verdict on petitions challenging the approval for the cultivation of genetically modified mustard. Justice B.V. Nagaratna quashed the approval granted by the Genetic Engineering Appraisal Committee and the Ministry of Environment and Forests, while Justice Sanjay Karol upheld it. The bench directed the registry to therefore place the matter before the Chief Justice of India to form a larger bench to hear the case afresh. The Union government had previously agreed not to implement the decision during the hearing. The case involves multiple public interest litigations challenging the Union government's decision to commercially cultivate and release genetically modified mustard named HT mustard DMH11. This represents the first instance of a transgenic food crop being planned for cultivation in India. The divided opinions reflect the contentious nature of genetically modified crops in the country, balancing potential agricultural benefits against environmental and health concerns. The matter will now be referred to a larger bench for a definitive resolution. In a landmark judgment this week, a constitution bench of the Supreme Court ruled that states have the authority to levy taxes on mineral rights, unaffected by the Mines and Minerals Development and Regulation Act of 1957. The 9-judge constitution bench, by an 8:1 majority, clarified that royalties on mining leases are contractual payments, not taxes. Chief Justice D.Y. Chandrachud, writing for the majority, stated that the union list's entry 54 is regulatory and does not include taxation powers, which are reserved for the states. The court also noted that the MMDR Act does not limit states' taxing powers and that the term land in the state list includes mineral-bearing lands, thereby permitting states to tax them. Justice B.V. Nagaratna, however, delivered a dissenting opinion, viewing royalties as taxes and cautioning that allowing states to levy additional taxes could lead to uneven resource distribution and harmful competition among states, potentially disrupting the federal system. Following the judgment, Solicitor General Tushar Mehta and senior advocates Arvind P. Datar and A.M. Singhvi requested the court to clarify that the judgment would operate only prospectively, while senior advocate Rakesh Dwivedi opposed this request. The bench agreed to hear arguments on this point next Wednesday. In the Lakhimpur Kheri case, the Supreme Court granted bail to Ashish Mishra, son of former Union Minister Ajay Mishra, this week. This case involves the deaths of 5 persons in October 2021 when vehicles in Mishra's convoy allegedly ran over protesting farmers. The bench of Justices Surya Kant and J.K. Maheshwari initially granted him interim bail in January 2023, which was extended periodically. The court imposed several conditions on Mishra, including a directive to leave Uttar Pradesh within a week of availing interim bail and not to stay in the state of the NCT of Delhi during this period. However, this condition was later modified, allowing him to stay in Delhi. This week, the Supreme Court dealt with the Haldwani evictions, emphasizing the need for humane treatment and rehabilitation before evicting nearly 50,000 people allegedly encroaching on railway properties in Haldwani. A bench of Justices Surya Kant, Dipankar Datta and Ujjal Bhuiya heard an application from the Union of India Railways seeking to modify the order that stayed these evictions. The railways highlighted that a retaining wall protecting the tracks was demolished by the Guala River during the last monsoon, necessitating urgent access to a strip of land. The evictions were initially ordered by the Uttarakhand High Court in December 2022, but the Supreme Court stayed the order in January 2023, extending the interim order periodically. The bench questioned the railways about their actions against the alleged encroachers, many of whom have been settled there for decades. Justice Bhuiya criticized the railways for not initiating statutory proceedings, instead relying on a public interest litigation filed by a private individual. Justice Surya Kant noted that many residents claim title based on documents, making a PIL ineffective for resolving disputed facts. Additional Solicitor General Aishwarya Bhati requested an incremental lifting of the stay, citing the crucial role of Haldwani as the gateway to the Kumaon region. The court acknowledged the railway's needs but insisted on rehabilitating those affected. It directed the Union of India and Uttarakhand to identify the essential strip of land needed for railway operations and determine the affected families for rehabilitation. This matter is set for further hearing on 11 September. In an important development, the Supreme Court highlighted the deplorable conditions in Assam's detention centers this week, where individuals with doubtful citizenship are held. The bench of Justices Abhay S. Oak and Augustine George Massey noted a sorry state of affairs with inadequate water supply, sanitation and toilets. This observation came after reviewing a report from the Secretary of the Assam Legal Services Authority regarding the Matial Detention Centre. Previously, the court had directed the union government to deport 17 declared foreigners detained in Assam transit camps, with some detained for up to 2 years. Senior advocate Colin Gonsalves, representing the petitioner, criticized the inadequate review of the detention centre housing 3,000 people, emphasizing the need for a thorough inspection similar to the NHRC's approach. The court directed the Secretary of the Assam State Legal Services Authority to reassess the centre, focusing on food quality and kitchen cleanliness. A new report is to be submitted within 3 weeks, with the Union of India directed to respond within the same time frame regarding the deportation issue. In a significant update, the Delhi High Court issued notice this week on Umar Khalid's bail plea in the Delhi riots larger conspiracy case registered under the UAPA. A division bench comprising Justice Suresh Kumar Kate and Justice Girish Katpalya has sought a response from the Delhi police and scheduled the matter for further hearing on 29th August. The court also listed bail pleas filed by co-accused for the same date. Khalid, in custody since September 2020, awaits trial for his alleged involvement in the February 2020 communal violence in Delhi. His second bail plea was denied by the trial court in May, leading him to appeal before the High Court. Khalid filed a fresh bail plea after withdrawing his plea from the Supreme Court, wherein he had challenged the Delhi High Court's October 2022 denial of bail. In other significant news, the Delhi High Court has transferred the investigation into the death of 23-year-old Faizan to the Central Bureau of Investigation this week. Faizan was allegedly forced to sing the national anthem during the 2020 Northeast Delhi riots. Justice Anup Jairam Bhambani allowed the plea by Kismatun, Faizan's mother, seeking a special investigation team probe into her son's death. The plea filed in 2020 related to a viral video showing Faizan and 4 others being beaten by the police while being forced to sing the national anthem and Vande Mataram. His mother alleged that Faizan was illegally detained by the Delhi police and denied critical health care, leading to his death on February 26, 2020. Justice P.M. Manoj of the Kerala High Court passed an interim order this week staying the publication of the Justice K. Hema Commission report on issues faced by women in the film industry. The stay is for 1 week, suspending the State Information Commissioner's order to make the report public by the very next day. The Justice K. Hema Committee, established in 2017, studied and suggested solutions for women's issues in the film industry. Movie producer Sajiman Parail filed a plea challenging the order, arguing that publishing the report would violate the privacy of those who gave testimonies. The petitioner contended that even with edited portions, the interconnected nature of the film industry could lead to identifying individuals risking further harassment. The petitioner argued that the report includes testimonies of sexual harassment, but the alleged offenders were not given a chance to present their side, potentially harming their reputation and livelihood. This matter has been posted for August 1st for further hearing. The Calcutta High Court has lifted the restraint imposed on West Bengal Chief Minister Mamata Banerjee, allowing her to make statements against Governor C.V. Ananda Bose, provided that they are not defamatory. This decision came after Banerjee appealed against a single bench order that had earlier restricted her from making any potentially defamatory remarks against the governor. The restraint was initially imposed following Banerjee's claim that women had expressed fear about visiting the Raj Bhavan amid allegations of sexual harassment against the governor. The division bench, comprising Justices I.P. Mukherjee and Biswarup Chaudhary, reviewed Banerjee's appeal and determined that she retains the right to make statements against the governor so long as they do not cross into defamation. The court modified the previous single bench order and has scheduled the appeal for further hearing at a later date. This week, the Madhya Pradesh High Court commented on the long-standing ban on central government employees joining the Rashtriya Swayamsevak Sangh or RSS. The bench of Justices Sushruth Arvind Dharmadhikari and Gajendra Singh highlighted that the Ministry of Personnel, Public Grievances and Pension recently removed RSS from the list of banned organizations for central government employees. This decision negates the effect of office memorandum that had been in place for 5 decades. The court was addressing a plea by a retired government servant seeking permission to join the RSS. The judges remarked that previous union governments had labelled the RSS's apolitical activities as communal and anti-secular, resulting in significant consequences. They expressed regret that it took 50 years to liberate from the restrictive don't join list what they described as an internationally renowned organization, saying that the RSS engages in numerous apolitical activities. The court emphasized that preconceived prejudices against a nationally and internationally acclaimed organization should not influence the executive's discretion in classifying it on the don't join list. They added that any future attempts to reinstate the RSS on this list must be based on extensive research. And that's a wrap for this week's Legal News Roundup. But before we bid adieu, the entire livelaw team has a small request for our dedicated viewers. As an independent and fact-driven media organization, we are deeply committed to fearless and ethical journalism. To continue bringing you the latest legal updates, especially in this dynamic audio-visual format, we rely on your support. So here's how you can help. Give our video a thumbs up if you found it informative. Share it with your family, friends, classmates and colleagues. Make sure you subscribe to our YouTube channel for more insightful content. Drop your valuable thoughts and feedback in the comments below and hit that bell icon to stay updated with our latest releases. Don't forget to visit our website at www.livelaw.in for our in-depth reports and analysis. Not only this, but the Livelaw channel offers memberships for only ₹89 per month. Become a part of LL supporters today to access exclusive perks such as loyalty badges next to your name in comments and live chat, priority reply to comments, and for our student pass audience, early access to explainers and legal updates. I'm your host Ostika Das and it's been a pleasure bringing you this week's Legal News Roundup. Until next time, stay informed, stay engaged, and stay tuned to Live Law. Thank you for watching.